Welcome to the debate. Our focus today is one of the most persistent and complicated tensions in American law, interpreting the Seventh Amendment. Now, this clause preserves the right to trial by jury in suits at common law and federal courts. That language, it's a direct reference to 1791 English legal practice and, well, applying it to modern complex litigation, new statutory causes of action, entirely new legal procedures. It's a profound challenge. So the central question we're exploring is this. How should federal courts interpret and apply the historical scope of the Seventh Amendment civil jury right in, well, our contemporary legal system? All argue that preserving the right requires a renewed commitment to a rigorous, categorical, historical analysis, really defined by those distinct lines between legal and equitable jurisdictions that existed back in 1791.
And I'll contend that such a strict, almost arcane historical inquiry is often, frankly, impossible in our modern merged system. I think the protection of the right has to focus dynamically on functional concerns, making sure modern procedures don't simply strip the jury of its rightful authority.
Okay, so let me start. The text itself mandates that we look backward, right? Because the right must be preserved. But preservation doesn't just mean finding a rough 1791 analogy. It requires a nuanced and precise understanding of the division between law and equity that defined the English system then. I believe the prevailing judicial approach, which often kind of boils down to the Terry test, separating the claim from the remedy, is fundamentally anachronistic. It seems to assume law and equity were these discrete, self-contained fields, but, equity's entire jurisprudence was defined by its supplementary relationship with the common law. It operated in three distinct jurisdictions: exclusive, concurrent, and auxiliary. To get conceptual clarity today, we have to recognize that certain historical categories were simply never suits at common law. This is crucial, where equity held exclusive jurisdiction. Think of trust law or undue influence, where the court of equity developed the entire field of substantive law itself. In these specific areas, even monetary awards, things like equitable compensation or surcharge, were always and exclusively equitable. Always.
Furthermore, we have to acknowledge that equitable case aggregating devices, like the class action or interpleader, these were historically creatures of chancery. They fall outside the scope of the preserved jury right. So a more refined, categorical approach is needed for both accuracy and, frankly, manageability.
Okay, I see that, but I come at it from a different way. While historical fidelity is commendable, requiring a judge to constantly, rattle through dusty attics of ancient writs, trying to map complex modern claims like, say, RICO or sophisticated environmental litigation onto some perfect 1791 analog, that's often an exercise in impossibility. We've seen the Supreme Court's efforts here described as, frankly, tortured, and I think rightly so. The emphasis must be dynamic, ensuring the substance of the right is preserved against modern encroachments that threaten the jury's core fact-finding role. I'd argue that the greater practical threat to the civil jury today isn't the theoretical complexity of a claim, but the evolution of judicial procedure itself. So for me, the key determinant should focus on the function of the claim and the nature of the remedy sought. When the government seeks punitive civil damages designed to, quote, punish and deter the wrongdoer, as the Supreme Court confirmed recently in SEC v. Jarkisy, that claim is definitively legal in nature. It requires a jury. It doesn't matter if the claim originates in an administrative agency or a court. If the remedy is penal in function, the right must attach.
That's a fascinating pivot, and it leads us directly to, the functional limits of the jury, particularly when we talk about complexity. While the Zenith case ultimately rejected a formal historical basis for a complexity exception, the underlying functional challenge is acute, and it has profound implications for due process, I think. Consider the old IBM Memorex antitrust litigation back in the 1970s. That trial was, an organizational disaster. 96 days of proceedings, 83 witnesses, something like 19,000 pages of transcript. And the jury, after 19 days of deliberation, simply failed to reach a decision. The judge eventually found the case, quote, beyond the ability and competency of any jury to understand and decide rationally. Now, Lord Devlin's research following that suggests that back in 1791, the English chancellor would have considered the practical abilities and limitations of juries. And functionally, they might have taken cases too complex for jury resolution into equity jurisdiction. This wasn't through an explicit rule, mind you, but through the chancellor's inherent power to intervene when common law procedures failed to achieve justice. So when a case is extraordinarily complex and protracted, the Fifth Amendment's Due Process Clause, which aims to minimize the risk of erroneous decisions, argues compellingly for a bench trial. The due process need for a rational verdict arguably sometimes overrides the historical process.
I'm sorry, but I just don't buy that the constitutional right to a jury trial can be set aside simply because judges believe they are better at it, or that complexity somehow magically creates a constitutional loophole. The denial of the jury right based on complexity, it's constitutionally unsound precisely because it overrides the clear command to preserve the right. Yes, okay, complicated cases were functionally rare at common law, but we have to be precise about why. It wasn't because some explicit complexity exception existed in the books. It was because the old procedures, things like strict pleading rules, very limited discovery, restrictive rules about joining parties and claims, these functionally prevented hyper-complex cases from ever reaching the jury box in the first place. When we look at a damage action, like antitrust, it has always been legal in nature.
We shouldn't allow our sort of functional anxiety about modern complex litigation, which is really a result of the merger of law and equity procedure, not some historical limit, to let us create a new judicial exception that just undermines the constitutional mandate. The Zenith Court, I think, was right to be skeptical of judges trying to predict how some hypothetical 18th century chancellor might have reacted.
While that due process concern is vital, let's pivot maybe to what seems to be our main definitional fault line here. Are we classifying these claims based on the historical court that heard them or the modern remedy they seek?
Your insistence on the primacy of the remedy, it fails precisely when we look at equity's exclusive jurisdiction. It's not enough to just look at the dollar sign. Focusing purely on whether a remedy is restorative or punitive, it ignores where the substantive law actually developed. Take trust law, right? The paradigm example. The entire legal field, including all the doctrines around fiduciary duty, was developed exclusively in courts of equity. When a breach of trust occurs and the court awards equitable compensation or surcharge, which, for the non-chancery lawyers listening, is essentially a monetary award for loss within that specific trust context, that remedy was always equitable.
It doesn't suddenly become legal just because money changes hands.
Okay, but
A failure to recognize these distinct historic categories leads to the really anomalous result of forcing jury trials in areas like fiduciary breach claims against a trustee, where the entire substantive doctrine originated outside of common law. As the Supreme Court recognized in Signacorp v. Amara, trust law remedies were, quote, exclusively equitable prior to the merger.
I acknowledge the historical nuances, I do, especially with exclusive jurisdiction. But the dynamic approach, which has been affirmed by the Supreme Court, places greater weight on the nature of the relief sought precisely because those historical lines have become so incredibly blurry and, frankly, impractical to trace in many modern contexts. The Jarkessi decision, the one addressing government seeking civil penalties, it's highly instructive because it gives us a manageable modern standard. The court basically said the key distinction for monetary awards is whether they are designed to punish or deter the wrongdoer, making them legal, requiring a jury, or solely to restore the status quo, making them equitable. The court explicitly stated, and this is important, that the remedy is all but dispositive when determining if a claim is legal in nature, at least in the context of monetary damages. Trying to shoehorn every new statutory cause of action like complex securities regulation or environmental penalties into some 18th century exclusive jurisdiction framework. It's an administrative nightmare. It forces judges to become amateur legal historians, which is probably why the tests often feel so, tortured. By focusing on whether the remedy is penal in function, We provide a clearer, more practical, and dynamic safeguard. It ensures the constitutional right applies meaningfully to the vast regulatory landscape Congress has created.
I'm still not convinced by that line of reasoning, primarily because it ignores that the historical structure gave us more than just trust law. It also gave us some of the procedural tools you're now arguing against, or at least whose effects you're concerned about. We also have to consider case aggregating devices. The class action, for instance. It was invented by equity specifically to manage the multiplicity of suits problem. The idea that you needed a unified court action when lots of people were harmed by a common defendant. These suits were not, at their historical core, suits at common law, even when they ultimately sought legal remedies like damages. If the device itself, the mechanism used to bring the parties together, is historically equitable, the jury right shouldn't necessarily attach just because money is sought at the end. Your remedy-only focus kind of destroys these historical jurisdictional categories wholesale.
But the most pressing issue, I think, and one you haven't fully addressed perhaps, is the procedural erosion of the jury right in practice. Even if we could perfectly agree on what a common law suit is, procedures like summary judgment fundamentally alter the 1791 allocation of power between judge and jury. That's undeniable. Before trial even begins, judges now determine if there is enough evidence for a jury to even hear the case. They're effectively taking the fact-finding role away preemptively. At common law, the only remedy for insufficient evidence presented at trial was ordering a new trial before a different jury. The judge never unilaterally threw the case out based on pretrial findings, especially not findings gathered through the kind of extensive discovery we have today, which itself comes from equity.
Right. Discovery is equitable.
Exactly. So this shift, combined with that extensive pretrial discovery taken from equity, allows judges to decide really fact-intensive questions that were traditionally reserved for the jury. It profoundly shrinks the preserved role of the jury in a way no 18th century common law judge could possibly have imagined.
That's a compelling argument about the power dynamics, certainly. But have you considered that these modern procedural tools are perhaps essential adaptations required by the merger of law and equity? The systems are just fundamentally different now. Pretrial discovery, as you noted, it's drawn from equity's auxiliary jurisdiction. And yes, it gives parties vastly more information than was ever available under those rigid, sometimes truth-defeating common law writs of 1791. So when you have that much information available pre-trial, surely you must have a mechanism for assessing its sufficiency. Allowing judges to assess that now available evidence via summary judgment, while, yes, controversial in some quarters, serves a crucial judicial interest in efficiency and, importantly, minimizing the risk of erroneous decisions, especially in those complex cases we talked about earlier.
The right preserved is the substance of the common law right, which arguably requires adaptation to fit a modern procedural framework. You could see summary judgment as an adaptation, ensuring that disputes lacking genuine issues of material fact don't waste the time and resources intended for real jury disputes.
I appreciate the nod to efficiency. I really do. But that adaptation comes directly at the cost of the jury's preserved power. What you're arguing, essentially, is that because we merged procedures and allowed equity's discovery tools to dominate, we must also allow judges to step into the common law shoes of the jury before trial even starts. I maintain that if there is any disputed fact whatsoever, the judge cannot legitimately determine that the evidence is insufficient to proceed. That determination, the one that leads to dismissal, is the quintessential act of fact-finding that the Seventh Amendment explicitly preserves for the jury, not the judge.
Well, the debate over the Seventh Amendment right to a civil jury trial clearly reveals this persistent, foundational tension between achieving historical fidelity and meeting modern functional demands. I continue to maintain that preserving the right requires a commitment to a refined historical analysis. We really must recognize that areas historically outside of common law, specifically equity's exclusive jurisdiction over substantive fields like trust law and these equitable aggregation devices like the class action, they should remain judge-decided to ensure conceptual clarity and avoid anomalous results in our merged system.
And I continue to contend that focusing on such, arcane historical parsing risks making the right irrelevant in contemporary jurisprudence, particularly when faced with all the new statutory rights created by Congress.
The focus has to be on dynamically protecting the substance of the right against modern procedural encroachments, like the ever-increasing scope of summary judgment, and ensuring that any claim seeking punitive legal remedies receives the jury trial guaranteed by the Constitution, consistent with the practical guidance from the Jerkesi decision.
Both perspectives, I think, highlight that the Seventh Amendment's preservation clause, whether you interpret it through strict historical categories or through dynamic adaptation to modern procedure, necessitates rigorous attention to the delicate and clearly evolving division of power between the judge and the jury.
Absolutely. It remains a foundational and perpetually contested issue in American jurisprudence.